afternoon, everyone. To talk about third-party ownership, or TPO, and to that end, it's important to consider the provisions set out in Article 18b pertaining third-party influence, and the explanation is pretty simple. Party holds an economic interest in a player's future transfer. It may also have a say in that player's transfer and or employment-related matters. So keep that into consideration. We're going to go back and forward with TPI also that we saw last week. But without further ado, let's just dive into our topic for tonight: third-party ownership, or TPO. So according to Article 2G of the FIFA statutes, one of its objectives is as a governing body of world football is to promote integrity, ethics, and fair play with a view to preventing all methods or practices such as corruption, doping, or match manipulation, which might jeopardize the integrity of matches, competitions, players, officials, and member associations, or give rise, of course, to abuse of association football. So to ensure that objective, FIFA has taken a number of measures aimed to eradicate those activities and practices that pose a threat to football's integrity and are liable to tarnish its reputation and or hinder the preservation of its essential values. Among these risks or threats, and also, of course, as a consequence of the ever-growing and more attractive football transfer market, FIFA has identified the possibility of negative and abusive third-party ownership of players' economic rights. Such practices also create the risk of interfering with clubs' freedom and independence, TPI, compromising football integrity and reputation, as well as its essential values. It may also be highly detrimental to the very interests of players. So basically, we can see, as well as in the case of TPI, third-party ownership provisions set out in Article 18 is aimed at protecting clubs' independence, right? Also, the integrity of the competitions, but as well the interests of players who stand at the heart of the international player transfer system. So also FIFA is the opinion, and I'm saying I'm not, but I also think you got to go case by case, of course. The prevailing interests of third-party investors seems at odds with the principle of contractual stability as set out in Article 13 of the RSTP. So subsequently, in 2015, FIFA, among other measures, implemented Article 18 with the aim of preventing the phenomenon of speculative investment by third party in exchange for a percentage of players' economic rights. It also introduced the definition of third party, which currently reads as follows. This definition as set out is the definition 14 set out in the regulation on the status of transfer of players. And it reads as follows. Third party would be a party other than the player being transferred, the two clubs transferring the player from one to the other, or any previous club with which the player has been registered. So Article 18 is quite a big article. So we're just going to read the more relevant parts for the purpose of our session. So Article 18 on TPO of players' economic rights. Number 1 states that no club or player shall enter into an agreement with a third party whereby a third party is being entitled to participate, either in full or in part, in compensation payable in relation to the future transfer of a player from one club to another, or is being assigned any rights in relation to a future transfer or transfer compensation. Also, number 5 states that by the end of April 2015, all existing agreements covered by paragraph 1, that's TPO, need to be recorded within the transfer matching system, or TMS. All clubs that had signed such agreements are required to upload them in their entirety, including possible annexes or amendments, in TMS, specifying the details of the third party concerned, the full name of the player, as well as the duration of the agreement. This disposition provision, is already in place and is valid. All TPO agreements must be uploaded through the TMS, as we will see further down the presentation. Lastly, number 6 states that the FIFA Disciplinary Committee may impose disciplinary measures on clubs or players that do not observe the obligations set out in this article. So basically, the provision on TPO was implemented to avoid financial speculation with respect to the transfer of players and the respective payments. The provision targets a practice according to which third parties will hold an entitlement in what is known as the economic rights in a player. We're going to explain what are economic rights in a few slides. This gave rise to speculation, harmful activities toward players, and conflicts of interest, risks related to the integrity of competitions and the transparency of the international market, transfer market, as well as the development of harmful other developments harmful to football overall. So the objective for the implementation of Article 18 there was that the financial revenues generated by clubs due to their transfer activity remain within the football family. So that's the rationale behind it. Article 18 there does not preclude clubs from obtaining external financial aid. You can still get financial aid. It's just that you cannot secure those financial aids with granting third parties the rights to any future transfer of a player, economics or otherwise. The provision is directed at clubs and also players. Should the FIFA disciplinary committee conclude that an agreement is in breach of Article 18 there, the relevant club and or players may be sanctioned pursuant to Article 18 there, paragraph 6 that we just read a few slides back. So let's go over the concept of economic rights. But in order to explain what economic rights means and entails, we first have to talk about federative rights. And federative rights are basically the rights granted to a club, not the player. It's the right granted to a club to register a player to in a certain competition or play in official matches. So it's the right of a club to register a player to play for him, right, in the relevant competition or league. That's the federative right. So when a player is transferred, these federative rights are acquired by the engaging club. That transfer of the federative rights has a value, and that value is what is known as economic rights. Those economic rights over a future transfer of a player cannot be assigned to third parties, as we will further explain in the presentation. So Cascades law describes economic rights as an ordinary contracts right, and the club holding the player's employment contract may assign with the player's consent. It's always important. Slavery is long gone. The contract that with the player's consent, it may assign the contract right to another club in exchange for a given sum of money or other consideration, otherwise known as the economic rights to the performance of a player. If you want to further study this topic, please refer to Case Award 2004-8-635, RCD Español de Barcelona, Sociedad Anónima Deportiva versus Club Atlético Vélez Sarsfield, and Case Award 2004-8-662, RCD Mallorca versus Club Atlético Lanús. So another important thing to point out is that the federative rights to a player can only be held by one club at a time. It cannot be divided or assigned to different clubs at the same time, just one club, as opposed to the economic rights that can be assigned to different clubs or parties, clubs or players within their third transfer, and it can be basically assigned to different clubs, not just one. So this is the prohibition in general in regards to TPO. Article 18 therefore forbids third-party investment in a player's economic rights. Clubs remain free to pursue external investment as long as investors do not secure it by receiving a share of economic rights of players. So receiving monies from third parties for investment or for a loan is not prohibited. What is prohibited is to grant that third party any type of right, economics or otherwise, in the future transfer of a player. That is prohibited, not the funding of a club, okay? This becomes important, for instance, when clubs negotiate an agreement with a third party for a possible financial investment or loan for the club. It cannot be secured with, again, any rights in regards to a future transfer of a football player. So pursuant to the definition set out in the RSTP, the parties entitled to receive compensation for the future transfer of a player are only the releasing club, the player subject to the transfer in its own transfer, because if it's in another transfer, it will be considered a third party, and another club where the player was previously registered. So let's talk about Again, in regards to this amendment, it was amended in 2019 following various decisions from the FIFA disciplinary committee. So the decisions of FIFA make necessary the implementation of this definition the way it stands today. So FIFA disciplinary committee basically considered that a percentage promised to players on their own future transfer is to be seen as a part of the remuneration on their employment relationship with the clubs and does not represent a violation of Article 18 ter. Please study, among other FIFA disciplinary committee decisions, the decision of the 18 and 26 of June 2008, and namely the cases of Werder Bremen, Panathinaikos, Colo-Colo, and Club Universitario de Deportes. As stated, it must be noted that a player as an individual would still be considered a third party if the transaction in which they are involved is not their own transfer. So they only will be entitled to economic rights in their own transfer pursuant to employment considerations. So let's talk a little bit about the services provided by football agents and the provisions set out in Article 18 ter. So for the avoidance of doubt, an agent is considered a third party in regards to the economic rights of a player. So if you have an agreement where an agent is assigned economic rights on the future transfer of a player, that would be null and void and subject to sanctions. Well, not null and void, but it will be subject to sanctions. We'll talk about that later. Therefore, as confirmed by the FIFA Disciplinary Committee, contractual provisions which grant a football agent the ability to receive a percentage annual remuneration linked to the future transfer of the player are contrary to Article 18 ter. Please, among others, study, if you so desire to expand, FIFA Disciplinary Committee decisions on the cases Santa Clara Accords, Faisal FC, and FK Spartaks. It is also worth mentioning that the calculation of the transfer compensation shall not include any sell-on fee in favor of the agent, and if included, may also lead to a violation of Article 18 ter. So, notwithstanding what has been said, as FIFA case law, an important distinction shall be considered. Football agent representing a party to a transfer may enter into a representation agreement and, of course, be entitled to receive compensation for the services provided in that specific transfer. However, services by a football agent as a part of a specific transfer do not extend to receiving a percentage of the player's economic rights if that same player is subsequently transferred where the football agent does not act or provide services as a part of that subsequent transfer. The agent needs to render the services in order to be paid for its services, not for any third-party rights, because it's not entitled to them under FIFA regulations. So some general considerations from FIFA case law pertaining to Article 18 ter. Well, the wording of Article 18 ter is very clear and leaves no room for interpretation. If a contract grants, a provision in a contract grants any third party economic rights or any type of right in regards to the future transfer of a football player, is in violation of Article 18 ter. It doesn't need to materialize. That is to say, the payment doesn't need to be made or the transfer actually perfected. Just the fact that it's agreed upon in a contract will be suffice to be in breach of Article 18 ter. Every clause shall be interpreted according to its wording, the real intention of the parties, and the rationale behind Article 18 ter. No contract can grant any kind of financial right or other type of right to a third party in relation to the future transfer of a player. These are the basic principles that, pursuant to case law, FIFA case law, we have to be very clear about. So usually contractual agreements in contravention of Article 18 ter also entail, I was spoken at the beginning, a possible violation of Article 18 bis. Also, the content and nature of the term 13 party has been reinforced. It does not apply to the player being transferred, to the two clubs transferring the player, or to any other previous clubs where the player was registered. We're just going over the main principles over and over again. The applicable standard of proof, just as in the case of Article 18 bis, The applicable standard of proof to consider a possible violation of Article 18.3 is the comfortable satisfaction of the committee. Why? Because it's a disciplinary proceeding, and therefore the standard of proof will be higher than the civil one, that is a balance of probabilities, but it will be lower than the criminal standard of proof that is beyond a reasonable doubt. So the standard of proof will be the comfortable satisfaction of the committee. The degree of the club's liability, the seriousness of the violations, and/or the endangerment of the legal asset protected are factors to be considered for the imposition of the relevant sanction. Okay. ¿Alguna pregunta, Dani, en este momento?
Luis, no tenemos ninguna pregunta.
Ninguna tampoco acá. Okay, so let's continue. No questions so far. So let's talk about some considerations on behalf of the Court of Arbitrations for Sports pertaining TPO, third-party ownership. So some background. Since the implementation of Article 1830 in the RSCP regulations in 2015, so those are nine years almost, 17 clubs have been sanctioned for entering into agreements with third parties in contravention of the TPO provision. Therefore, the CAS case law in regards to TPO is much more limited than in relation to Article 18bis. In fact, there is only one concrete precedent that simply analyzes the nature, objectives, and the legitimacy of Article 18 in detail, and that is the famous Serain versus FIFA case, and that is identified as CAS Award 2016-A-4490. In that decision, CAS recognized the validity of the provision, the objectives pursued with its implementation, its binding nature, and its compatibility with EU law. Furthermore, CAS considered that Article 18.3 does not violate, limit, or restrict, unlawfully affect any of the fundamental freedoms of the EU, and that the rule also seeks to achieve a legitimate aim that is aligned with the specificity of sport, just like Article 18bis. This interpretation also is backed up by other ordinary courts, such as the Swiss Federal Supreme Court and the Brussels Court of Appeal. So it is in compliance with EU law, European Union law. So furthermore, CAS, not FIFA, this is important because we already saw the position of FIFA in regard to TPO. Now we're going to see what findings CAS has confirmed in regards to the risks that appear to be associated to the practice of TPO. One, risks of conflict between the interests of clubs, players, and final or successive beneficiaries of investment agreements, risks related to the opacity of investors in questions who are beyond the control of the football regulatory bodies and who may freely proceed with uncontrolled disposals of their investment. Also, risks of infringement of professional freedom and the rights of players by being able to influence speculative interest in their transfer. Risk of match manipulation contrary to the integrity of competition. Why? Since the same investor could be involved in TPO in several clubs belonging to the same competition. That's an issue. Risk to ethics, since the objective pursuit is a speculative financial interest exclusive of sporting and even moral considerations in some cases. True. So, therefore, two conclusions can be drawn from the only CAS case so far on Article 18.3. That's it. That is the Serain case. One, very basic ones. CAS recognizes the validity of Article 18.3. It is in compliance with the EU law. A contractual provision granting a third party a financial right related to the future transfer of a player goes against Article 18.3 and is subject to sanction. So, and this is very important, the fact that a contract might be contrary to Article 18.3 does not mean that it becomes invalid or unenforceable, but simply that the club will need to face the disciplinary consequences of entering into a contract in contravention of this provision. Basically, the situation that one club that breaches Article 18.3 provision might be looking at is that they're going to be obliged to pay the percentage fee recognized to the third party, and also is going to be liable to disciplinary sanctions pursuant to Article 18, third para, numero 6 that we just read before. So basically, you're going to have to pay the money, and you're going to be sanctioned also. So finally, just like we did when we went over TPI, declaration in TMS, when clubs enter an international transfer into TMS, they must either declare yes or no to whether they have entered into a TPO agreement. By incorrectly declaring that there is no TPO, club failed to disclose full mandatory and correct information in TMS, the transfer matching system. Therefore, an infringement of Article 18 there also includes a failure to provide the mandatory information or entry of incorrect information in the TPO declaration in TMS. So if we don't provide the proper information, or we omit or actually straight up lie and about the existence of a TPO agreement, you're going to be in breach of Article 18 there and are going to be liable to disciplinary sanctions. So basically, that's our presentation for tonight, our session. I don't know if there are any questions. Dani, ¿alguna pregunta?
Ninguna pregunta, Luis.
Okay, so at this point, I just want to thank you for joining us. Of course, any questions you may have pertaining this or any other of our live sessions, you can please contact us, and we'll be more than glad to answer them to the best of our abilities. And we look forward to seeing you guys again next Wednesday. We'll be announcing the topics and to our social media accounts. So until then, guys, be safe. Thank you. Bye-bye.